Thanks everybody for coming in, and thank you, Concord again as well, and thank you, Singyo, for allowing the CREPA to organize and coordinate this seminar using your boardroom. So welcome. Thank you for all of you for tuning in. So one of the things that I wanted to do today was to talk about the new Landowner Transparency Act that came into effect a couple of days ago, which left a lot of real estate practitioners scrambling into terms of what needs to be done, what needs to be shown. But I wanted to give you some background into all of this stuff dealing with title, and that's today's topic. I wanted to introduce a little bit about myself. I've been a lawyer for 23 years. I've been doing mainly real estate, both residential, commercial, transactional lending, financing, as well as litigation when it comes to all kinds of issues dealing with real estate. It's important to know how all of these things affect title, because when you are selling and buying real estate and advising your clients about what's on and what's off, what needs to be removed, what needs to remain. A lot of it touches on sometimes cases in court, so you need to know how things are interpreted. So I wanted to go through this with you as well. And so I'll just go to my next slide. So this is myself. This is my contact information. And if you have any of you want to have a link to this the PowerPoint, you can contact CREPA and they can send this out to you as well. I have my information there as well. So without further ado, what I want to start today especially is in terms of the non-financial and financial charges that are on a title search, which you need to know about so you can avoid something called the Section 9 trap. The idea is that on the Section 9 of the standard real estate contract, this provision that says the seller is to provide clear title to the buyer, except for a number of things that are specified in that particular section. So in this presentation, the first part will be about this particular section. Part 2 is about some of the charges that you will most commonly see on a title search and what to do about them, or what to know about them, what's important to how to deal with them. Okay, know what they are, and then you know whether they should be removed, kept on, or buried, or something to discuss with your clients. Okay, and part 3, the new act that just came into force a couple of days ago, and why that has come about, and what does it mean for all of the buyers that are coming into the market and for existing landowners. So without further ado, Section 9 trap. Section 9, it says that the titles be delivered to the buyer except for a number of things, such as, and I've listed this out in this PowerPoint here, subsisting condition, provisos, restrictions. Basically, it means anything that's related to the government. You can have rights of ways in favor of utilities and public authorities, such as TELUS rights of ways and BC Hydro, etc. Existing tenancies are set out in Section 5, if any. And one of the things that I didn't talk about here too much, but maybe later on I will, regarding tenancies. Commercial lots, especially when there's registered leases on title. And then the last part, except as otherwise set out herein, which means that if there's something else that's supposed to remain, well, I'll write it down. But a lot of people would look at the title and quite often, hey, what is that? Should it stay or should it not? Should it go? So the common thing that has happened in the past is if you don't know what's in there, you say, hey, look, the buyer has seen the title. It's included as part of the contract, and therefore they should know what should be in or should be not in. Well, that is not the proper approach, mostly because there's case law, which has indicated that just because it's there, just because the buyer is aware of it, doesn't mean they accept it. So it's important to know that. And the case I'm going to show you in a few minutes actually talks about that. So I'm going to go to the next slide. So in September 16th, 2020, recently, there's some new clauses that had been approved by the BC CREA that relates to this issue. The first part is the law attached to the contract, attach the title search, so it forms part of the contract. add the terms in it, the quote unquote, the buyer and seller acknowledge that a copy of the title of the property is attached to the contract. But for this part, I would highly advise that you don't take it in and of itself alone and just leave the contract in and put it in there and not do anything with it, because of certain case law that has arisen that deals with this particular issue. And I'll tell you about the particular clause that I really like, that is in your, I believe in some of the guidelines that have been provided to agents as well. And but the other two things to add, like the second suggested recommended clause, specify which charges stay on. So this quote unquote, the buyer and seller agree that in addition to the accepted charges and encumbrances set out in section 9 of the contract, the following notations, charges, encumbrances will not be discharged upon completion of the purchase and sale contemplated by the contract. And then you list everything out that's supposed to stay on. Okay, that's if you really know your stuff and you know your title search and you know what's inside it, know what needs to be in and out. Well, another way to do it is to attach it and then talk about which ones stay on and which ones are to be removed. So then you put this clause in, okay, are to be discharged in accordance with section clause 14 of this contract. But I want to go back to item number 1, because if you don't want to specify which ones are staying on and want to attach tab search and show it all, you can do this, okay? Put this clause in. So you put in this clause and say the buyer and acknowledges and accepts that on completion the buyer will receive title containing, in addition to any encumbrances referred to clause 9 of the contract, any non-financial charge set out in the copy of the title search results that is attached to and forms part of the contract. So the idea is that you put in here specifically any non-financial charges that are set out there. Okay, so, and this was also found in your issue of legally speaking, that's issued to all the realtors in that, and I think it's the link is, if you can type it in, or if you get the hyperlinked PDF from me, you can click on it and access that clause right there, or you can copy and paste it and move on. But this is better than just the first item, which is a suggested clause. Now, the reason why I want to talk about this is because of a particular case. It's called JPB Developments Limited versus Lien. It's listed as Cellmark Realty, but it's actually Cellmac. I know most of you know that it's Cellmac, not Cellmark, but I think there was a typo in the in the name on which they filed the case. So the idea is that reading this case is very important, and if you ever wanted to, I'll send that case to you. But it is always good to cross-check the title search with section 9 to see if there is a non-financial charge that needs to be added to the list. And if you're in doubt, you don't know what it is and what does it mean, ask a lawyer. But I want to talk about this case because of this. I'm going to tell you some bullet points. The buyer in this case had refused to complete because the seller would not remove a restrictive covenant in favor of BPP, which is the gasoline company. The seller sued and lost. The main reason is that the test is an objective one. Whether a material defect on title exists, it is not based on how important the defect is to the buyer, just that on the face of it, it is a defect. Now, in this particular case, it was a restrictive covenant in which they prevented the owner of the land from certain a building, or make sure that they have to keep the trees at a certain height, cannot build on certain parts of the property. The seller who sued the buyer for not completing says, look, you didn't examine how important that that restriction is to the buyer. What if they didn't want to build a house on that particular area of the land? What if they didn't want to put a fence over there? What if they didn't need that tree there or not? The courts basically, and they refer to Court of Appeals cases as well, and this should be pretty important, is that it's an objective standard. Whether or not someone has to ask for someone else's permission to do something on their land is objectively something which is a material latent defect. The idea that someone owning a land has to ask for permission from some body in order to do something on the land, regardless of whether they want to do something, is how important it is for them to build a deck or raise a fence or not. It's an objective standard, not a subjective one. So it's important to know that. So this case is really important as a good read to see, because basically the standard thing was done. The contract had the title search attached to it, and it says, and presumably the argument was that the sellers had argued in court that, look, they were aware of it. They knew that it was on that title search, and yet they completed, and therefore they should be accepted, and they should not have to use that as a reason to not purchase the property. Okay, so it's a very good one to read, and they refer to Court of Appeal cases in this one as well, because there are some arguments that was raised as to whether or not how important it is to know what the buyer's intentions were, but it's an objective test, not a subjective test. Okay, next one. Okay, well, what are some financial and non-financial charges? I just want to give you a brief outline of some really ones that are very common, and a little bit about what they are. So start off with the list. Covenants. Covenants is like a Latin word for a promise. So it's a promise to do something by the owner to do something positive, such as maintaining a pathway or riverbank or things like that. So it's positive promises to do something. Restrictive covenants are promises not to do anything, such as not to build over a certain part of the land, not to erect structures, not to most of the time it's not to obstruct or not to build something on top of a certain area of the property. And easements are agreements that allows the landowner to basically, on the property in which an easement is registered, it allows a adjoining neighboring property owner to have access to that land on or over or under for specified uses. And then you have other things such as rights of ways, which is more than just allowing someone. The other person has a right to access that part of the property. And then there's statutory rights of ways, which is government authorities, which are the ones that when you refer to the Section 9 exceptions, and this is something that is always there, you know that it's a government authority is by nature in and of itself a statutory right of way. But then there's those leases and options to lease. We mentioned that about earlier. So in BC, commercial titles where a tenant has a commercial lease registered, if the lease is less than 3 years, they're automatically enforceable for any new transfer rees taken over property, but not those that are over 3 years unless they're registered. So as against a new landlord. So the idea that we have a commercial lease, it's less than, let's just say that it's not registered and it's more than 5 years. It's important to know this fact, okay? But the problem is, like a lot of the situations, and I do a lot of commercial transactions as well, and I represent landlords where invariably, if the landlords are able to, they would put down leases are not to be registered, and there's no contractual provision allowing a tenant to register a lease no matter how long it is. So if you're able as a tenant to register it, then you have certain rights against a subsequent purchaser of the commercial land. It's important to know what these are. A few more things. Judgments. Of course, usually judgments are financial in nature. Court orders will be issuing a judgment which is registered against land, and then the property will then be determined to be like as collateral for the payment of that judgment order. You might be familiar with these certificates of pending litigation. It doesn't mean that the parties to that, and basically that piece of property, an interest in it, is tied up in courts. There's some lawsuits that affects the ownership of the land. So a CPL is registered to the public, so everybody knows there's a problem with the title. If someone is owed money, the land maybe is owned by someone else. So those types of issues. It's important to know, if you see a CPL registered, it may be important to, the land title office won't show you exactly what is being argued upon. So you have to go to the courts and go through, and if you can have online access, there's a service called Court Services Online. You type in the action number or the parties or even the name of the person on title, and you should at some point see the underlying case, the litigation case in courts that relate to this litigation. The problem with a CPL, and if you are thinking of purchasing it, it's invariably financial, invariably involves title and ownership to the home. So anything to, as an advice to anyone, never register anything after. Don't try to buy it, don't try to mortgage on it, don't lend money to a house owner that has a CPL registered, because everything is at risk after the CPL has been registered. Okay, so, and then we mentioned about a lease just a minute ago. So I'm going to move on to the next one. Now, Spouse Protection Act lien. It's not as common, but you do see it. So if there's an unregistered spouse on a property and there's a dispute as to the ownership of this, the unregistered spouse can file this lien as an interest to everyone that there's an ownership interest in the home, but not registered. So this person who is a spouse may be considered a beneficial interest holder. We'll talk a little bit more about what that means. So basically, someone who's not registered who actually owns it by reason of law, such as getting married or by other reasons. You might see notations on a title that refers to a builder's lien. So it refers to any person that has supplied labor or materials, so it's either or both, to improve a property, but who has not been paid. And some people think, well, what scope does that involve? Like how far? So it's very general in terms of labor and materials. So quite often, in the last couple of months, I've had a few commercial real estate deals where a garbage contractor, a waste disposal company that wasn't paid will slap liens on these businesses that were being tried to be sold. And so the seller all of a sudden has to deal with this waste disposal contract and deal with it in the courts while trying to sell the property. So the problem is it puts a big wrench into the whole idea of like trying to sell the home clear title with a builder's lien on it, subject to litigation in the courts. The thing about builder's liens and also about CPLs, which is flipped backwards here, regarding CPLs, it says here at the very bottom under the CPL segment, normally a CPL can be released so long as security is posted to the court for the amount claimed, similar to builder's liens. So the idea is that for the house or the property is only used as collateral for the loan. And if you can put security somewhere else, it's a matter of course that the courts will allow that to happen. Quite often lien claimants or CPL claimants says, hey, I can tie up this property and stop them from selling. As long as I have the lien on it, I can exert pressure on the parties who are registered on owners or above the CPL to pressure them into giving whatever is needed to the lien claimant or the CPL. Well, the thing about this is that if the security for the loan for the amount of lien of the CPL can be put into court, it's invariably the courts will order the removal of the CPL. Now, it's not like it's you have to get a negotiated agreement with the claimant in order to allow it to be removed. The problem sometimes is, and it's quite common to see, is that the amount claimed is a lot more than what is actually really owed. And that's the problem. So you might have to litigate that part. But the idea is that as long as monies are put into court or held in trust by a lawyer's account, trust account, these are more easily removable than and can be done prior to completion as well. Okay, so another thing, strata property liens. If the strata condominium is owed management fees or special levies are not paid, they can slap a lien onto a title, and these are invariably financial. I haven't seen one where it requires something for the landowner to actually physically do something. It's usually a fine that's not been paid. And of course, for strata properties, it cannot be transferred until something called a Form F, a certificate of full payment, is issued. And they will not issue one of those until all the monies that are owed are paid. Okay. Then you might see these things called land tax deferment agreements. And these are all, of course, when you see the word tax, and it's financial. No ifs and buts about it. The idea is that some residents in BC, permanent residents or citizen, usually 55 years or more or older, or a person with disabilities, they have to show incapacity or inability to pay the property taxes. And they can apply to defer their annual property taxes with the BC government. But when they sell it, they have to pay it all up. So the process would be to contact the Minister of Finance and ask for a payout amount that's going to be paid out on the day of completion. So this is a financial charge, but it's quite common, especially nowadays, to find. Okay. And then there's things which is notations that says that this land may be part of an ALR. What is an ALR? Well, to find out, first of all, if a piece of land is in an ALR, you might go to this website that I've provided here, a link. Tap in the PID number and you'll see whether it is in one or it is not in one. It's important to know that there are specific rules as to the use of the lands that are maintained in an agricultural land reserve. It's important to check to find out for the purposes of which your client wants to buy the property, whether the uses in which they want is allowed and permitted if it's inside one of these. And if you're not sure if it is or is not in one, then this is where you go. You type in this and you click on the link if you get the hyperlink from me, and then you can check and put it in and find out. Okay, now what do these look like? Okay, like you've seen some of them and described them. I just want to give you a quick snapshot as to what they look like. So covenants, you can see here, registered owner of charge, City of Vancouver. They talk about Land Title Act, Section 2015. These are positive things that has to be done. Statutory rights of way, so TELUS prevents people from building over any proposed potential or proposed or actual in use telephone lines or poles or things like that. Now, this is important for me, statutory rights of way. This is a good time for me to talk a little bit about title insurance and surveys. I had a client who had was selling a house 5 years ago. He had purchased a house in Burnaby. And he had bought title insurance, thinking, okay, I've got title insurance. I don't have to worry about if there's a problem with title. Okay, well, 5 years later, he's selling the home. He comes to me, and then the buyer lawyer provides me with a request and a notation saying that, hey, we did a survey on the home, and it turns out that your client's garage is built on top of a statutory right of way. And therefore, we need you to rectify the situation. So my client goes, oh, hey, Ivan, don't worry, I've got title insurance. And the title insurance will rectify any defects on title if it was not known at the time of purchase. So then they go back and says, well, was this statutory right of way registered at the time you bought it? Yes. Well, then it's not covered because if you knew there was a right of way, you could have easily discovered what the right of way was and how many feet from what section and how many, and how far along does it affect the property. Then you can easily measure and check the house to see whether your garage or any part of it was encroaching on this right of way. Therefore, is not covered. So the importance of that story, $7,000-8,000 later of negotiations with TELUS to allow for the client to continue having the garage built on the TELUS right away. Is that a survey will show you what's really there, whether or not a house or encroachment is affected by a physical structure on the house on a right of way. So don't just rely on title title insurance. If you see a covenant, you see a right of way, you can check it, and it's not covered by title insurance because you could have been able to discover it. As like anything, insurance is meant for anything that you don't know and you couldn't have known and nobody was aware of. But if you see this on your title search, that means you could have known, you could have checked, and you are aware. Okay, move on. Now, easement indemnity agreement looks like this. So easement and indemnity is what it actually means, that if you did something and you didn't allow something to happen, you have to compensate someone for it. So financial, but also not in a sense financial because it's a set amount of money that's owed or not, but there are some consequences to it. An easement and indemnity. Well, is it a hybrid? Financial and non-financial charge? Well, but it's registered owner of City of Vancouver. You were not likely if in doubt, include it in and don't leave it out. Then you see a land tax deferment act agreement charge. This is what that looks like. So you can see that who is the owner, Her Majesty the Queen and Right of British Columbia, and it restricts dealings mainly because you can't deal with it unless you can transfer it until it's been paid. Or anyways, so move on to the next one. Then you can see this Land Spouse Protection Act charge. This is the one I mentioned to you about an unregistered spouse to a property. And then one of the rules about this is that the property has to be something in a place in which the spouse had lived in. It's not an investment home that the spouse has an entitlement to. And the idea with these liens are like you can register it without having prior notification given to the other owner on land. So anyways, this is something that sometimes is chosen, how would you say, in preference to a CPL. A CPL, a certificate of pending litigation, you actually have to start a case action in court prior to filing a CPL. A Spouse Protection Act charge, you sign an affidavit saying that I am a spouse, this is a home that I live in or have lived in, and this is or maybe currently going in and out of, or not, or being prevented from living in, and I have entitlement to it because I'm a spouse. Okay, and you just file this on title. It's kind of like a builder's lien. It's very quick and very easy, and can do it without notice, and you don't have to start a claim in court before filing it. Next one, judgment. So this is what this is quite common. If you see a judgment and you see a bank, you know that it's a foreclosure action that started. You can search the foreclosure courts, civil Supreme Court BC, put in judgment. You won't see this number, the CA356. This is just the land title office registration. You won't find that in the court if you want to search court services online. You want to check to see how much the roll bank is owed, and quite often though, if you are looking for properties that are on foreclosure to purchase on behalf of a buyer, title search is ahead of judgment. Invariably, there is some foreclosure proceeding happening, and you don't know which stage along the foreclosure process that has happened, but judgment happens at the time the order nisi is given. So judgment is ordered. The client or the person who owns the house is given 6 months time in general to pay out the mortgage. Anyways, just put it out there in case any of you there are interested or thinking about how to find properties with in the midst of a foreclosure proceeding. Okay. Then the next one I want to show you, claim of builder's lien. So you see this. This is an oil tank removal company that had placed a lien on the property. Then we have this was done in 2015, and just to tell you the significance of liens that are registered on title, we're in 2020 now, and we're still litigating this case 5 years later. And I act on behalf of one of the purchasers that has to deal with this lien that was on the property that was slapped on by the vendor onto the vendor when they had owned this property. So, and we're going to Court of Appeals. So look at 6 years you can tie up a place because of a lien that was not dealt with at the time of purchase. Okay. Next one, then you have this thing is this legal notation you see here. This certificate of title may be affected by the Agricultural Land Commission Act, see Agricultural Land Reserve Plan 35, deposit, blah, blah, blah. So you get the PIN number, check it in. This is a place in Abbotsford. Find out, okay, well, what is the restrictions that are placed on this piece of land? Invariably, a lot of these are not in the cities, of course. You can find them in Richmond, Abbotsford, Fraser Valley, where there are primarily before in the past, and especially 1974, it was mostly agricultural. So they want to promote and encourage farming and less industrial urban density type of developments. Okay, so if you're planning a development and you want to look at this space and you say, hey, big piece of land out in Abbotsford, and better check, you might have problems later on down the line. Okay, so I think those are the ones that I want to show you. I just want to show you a couple of, if you had to actually pull it out and figure out what these things are. Okay, easements, for example. So you pull out an easement. This is what these things look like. You see these lines, you see the dwelling, the physical structure, and they have measurements as to where things are and how many feet they are from the property lines, etc. And then you get these title, and then you figure out, is there any encroachment? You can, I don't know if you see my cursor when I'm showing this, but let's see if I can get the highlighter thing going. and then you see the line here and the lines over there, and you want to see if there's encroachments, anything going beyond the lines, so the structure does not expand past the past the property lines or an easement, just to be sure. Okay, and these are non-financial, but they do have a substantial effect on a buyer's use of the land. Okay, I'm going to show you the next one. This is a similar one. They talk about easement area and how many square foot it is and how big it is and how long it is. So you can tell whether or not a certain property or a certain building or structure is encroaching or it's going to be a problem. And this may affect, like, if your client is planning to build something. Of course, they probably have surveys done, and these are all done, but maybe they didn't do these before they bought, and you want to check these things out before you have an architect or a builder that wants to build something. And you want to know whether or not they can fit within the space that you're given, or whether or not you have to negotiate with an authority to allow you to build. Okay, so this is a sample of a property that's inside. We go to the agricultural land reserve and type in the PID. This line over here, it shows you that your property that this person is buying is smack in the middle of one. Okay, so ALR, participating BCL sites. The green is all ALRs, and your lot is inside this chunk of land. Okay, so it's good to know, and you'll see that quickly in the map on the website. Okay, so I just want to show you that, and sample release documents, because hey, okay, once it's on, how do you get rid of it? It's good to know that, and how easy it is to remove it or not. For CPLs, you need a release letter from the person claiming the lease on the property. So the idea is that there's a lawsuit. This is placed on there's a lien placed, a CPL lien placed on it. The person who placed the lien, a law firm, has to sign a letter saying that the case itself has not been finished, or no judgment has been risen, but they're allowing it to be removed. And normally when that happens, is because arrangements have been made between the buyer and seller. For example, I have sufficient funds in my trust account, and I'll hold it in there upon the sale. I won't touch it until a court order and agreement has been reached by the parties, and then the other lawyer would sign this letter allowing me, the buyer, to file it on title, so that the CPL can be removed and released. And then for land title tax deferment, one of the things we do is we request the payout statement from the PC government, and they start listing out, taxes were not paid in these years. This is how much is owed, and you just take this amount and pay the government, and they will remove the lien for you. Okay, and it usually takes about a week or two to get this done, and the government will release it as for you, so you don't have to be responsible for preparing documents for its release. Okay, so anyways, I just want to show you this because you'll see it, and sometimes the customer, your buyer may, or your seller may ask you, how do I get rid of it? How long does it take? Or should I be worried about it? And how do I remove it? Okay. Next thing, I just want to tell you a little bit about the last part, the last 10 minutes or so, is the Beneficial Ownership and Landowner Transparency Act. And what is beneficial ownership? Basically, there's all been initiatives from the BC government to crack down on money laundering. They also want to crack down on ownership of properties and not knowing who owns properties in order to effectively find people they can tax that has been avoiding being taxed. Basically, that's what it's all for enforcement purposes. So the first thing, the purpose of the Landowner Transparency Act, as I mentioned, to make beneficial owners information available to the public and to support tax authorities, law enforcement agencies, and relevant regulators to target fraud, money laundering, and tax evasion. The Ministry of Finance is going to be managing the enforcement. Canada Revenue will have access to information, and it's the Land Title Authority that will be collecting all this information and requiring everybody purchasing an interest in land to report all this information. And something to note, the Landowner Transparency Act, it came into effect a couple of days ago. For existing owners, but every new owner or purchaser or anyone getting on title to the land where a property transfer tax form has to be filled out, has to put all this information in. Deadline to file for people who own properties now, who already before November 30th, they have 1 year to register. So everybody owns land, they have to register whether the land they own is just for themselves or someone else who owns it, companies and corporate lands. And this applies right across the board, whether it's commercial or residential. Of course, limited access by some people. The public can't access all the especially sensitive information, but full access to enforcement authorities such as the CRA. And all entities are required to disclose ownership. You have trusts. So some properties are held through trust. Then you have to notify all the information, including SIN and residency and permanent residency of all the owners, partners, shareholders, silent shareholders, silent partners, silent beneficiaries, who are the settlors, who are the trustees. It's quite significant. So requirements for corporations: who has 10% or more of the shares, who can elect the majority of the directors of the company. So a person can have an agreement with the shareholders to allow a third party to have that control and be the deciding vote, like a silent partner. Okay, well, they can have powers to choose who the majority of the directors of the company are. They have to be reported who they are, what their name is, their SIN numbers, their residency, permanent residency, and so on. For trust, anyone who has direct or control of the trustees who are benefiting who has in control of deciding who are the beneficiaries of a trust, who gets what from the trust assets. And for partnerships as well. You can have two or more parties that own the property, but only one party is registered. Well, who has rights to 25% or more of the profits? So they may not be entitled. It could be many of this you can find in joint ventures. So someone has land but doesn't have the monies and abilities to develop. So they have a partnership with the developer, but the title remains with the person on title. And it's a joint venture. But then look at this: who has the rights to 25% or more of the profits or assets? Well, okay, if you know this agreement is there, and there's certain rights that are given, you have to disclose. But also, who can have rights to approve or remove the majority of the partnership's managers? That's another thing too. So you may not, you can have 70%, but you have no voice. Well, okay, that can be done. You have an agreement to deal with that. Okay. What you need to know about the LOTA? Well, information about all these owners, whether they're registered, they're shareholder, they're a settlor, they're a trustee, they're a beneficiary. Citizenship, PR status, date of birth, the registered records office, business numbers, headquarters, where you're registered, doing business as, any kind of sole proprietorship run through the company. And of course, everybody who are buying properties now have to look at a different cost on top now. Just the filing fee itself is like $40 minimum. But yet the work involved, I just finished a contract of purchase of sale where a company had, one company had 4 shareholders. Each shareholder is a company. Each company, and then them in and of themselves, has other beneficiaries and owners, and we have to report everybody down the line. And that's like, you have a typical property transfer tax form, just 4 pages long. Now it's going to be 15 pages long. Okay, it's a lot of work. So what is a beneficial owner? Well, a person who is not registered an owner, such as an owner of shares, and I'm talking about companies as well, not just entitled. So someone who may be a silent owner of a company, and the company is entitled to the home. So any person or who has rights or powers over control over the company, and then therefore the property. Okay, powers, rights, and means can be an indirect control, or it can be rise. And that kind of control can arise from many different ways. Rights as a matter of law, I mentioned earlier. We had the people who can put down a spousal protection act lien because they're a spouse, because they're an owner by marriage or cohabitation for more than 2 years. The powers arise from the Family Law Act and the Divorce Act. Then you can have other ways in which those rights occur. Rights as a matter of equity or legal presumptions. For example, transfers of property between 2 adults in BC with no monies exchanged. It's presumed that the person who received the property is holding it in trust for the person who gave it to them if they're an adult. there has to be something else if you want to have it as a gift to confirm it's really a gift and not just something held in trust, such as a declaration of gift. So when is a gift not really a gift? Well, okay, when it is made between adults without anything confirming that it is meant to be a gift. Okay. So there's a couple of other ways in which those beneficial rights may accrue. Co-ownership agreements, bare trust agreements, partnership agreements, joint venture agreements, shareholder agreements, and which rights may accrue. And for someone to know how to report who is an interest holder in a company, who is a beneficial owner of a property, you have to ask and look at all these things to find out. Okay. So this is an example of an indirect control one. So a partner or shareholder holding 20% of the voting shares, but is a spouse of another partner shareholder who holds another 40. So anytime that they want to vote, they're going to be 60. The last three partners each hold 10%. Neither of the 10% holders can do much on their own or with themselves, but only if they're in conjunction with the person, with more than one person. So you can have this kind of a situation. You can see how hard it is to figure out who really is in control. And that's what the government is trying to crack down on, finding out who has control. And then they have this new definition that's put into the Act for the Landowner Transparency Act, is control through or by a chain of intermediaries. So you can have an OpCo, is a registered owner, and OpCo operation company is in turn owned by another company, HoldCo. HoldCo has the power to choose the director of OpCo. However, I do this just because we have to follow the leads and where everything goes. So we have a beneficial owner through a beneficial bare trust agreement saying someone else really owns something, but they're just not registered. Shares of Headco is owned by one person, Mr. Chen. I'm just saying that. I don't mean you, Mr. Chen. I know that there's a Mr. Chen out there. Okay, is part of this relationship here. So you have to report this whole chain of intermediaries to find out who is really in control. Okay. So that's my presentation for today. I was asked to give 10 minutes of time for questions. So if you want a hyperlink, you can send it to a request to the CREPA directors. And again, thank you, CREPA, for allowing me to speak to today, present this material. My contact here, my cell phone, this is my cell phone. So in the event that you have a client and you want them to ask questions, maybe call my office, but this is for CREPA members. If you guys are professionals and can have some questions, you can ask me. And many of you out there know me already, that I'm available to give some advice and to your particular transactions. I prefer that, hey, if I do that, then the clients come as well, but not necessarily so. I'm here for CREPA and to help you guys out. Okay, thank you very much.
Hey, Ivan, there's a couple questions on the chat. Did you mind answering them?
Yeah, do you want to read the ones out? So for those who don't have a chat on their phones and typing through, you can choose which one you want, and we can go from there. Would you like to do that, May?
Oh, hi, Ivan. May I ask if the owner be able to transfer the same amount, the sum of the deferred property tax agreement, to the new house?
No. Any deferment of property tax is not transferable. The person who is buying the house has to apply on their own, because it's not a property space, and it's not a land-based decision by the Minister of Finance to allow an exemption or not. It's a person specific. A person who is elderly, mostly, or under disabilities, or other some kind of incapability, which they allow that to happen. They do their own assessment as to what is considered someone who is applicable to have a deferment of the property tax. I've seen single mothers. I've seen people with accommodationship, people with disability. They get disability income, so they're able to afford things, but not everything on their own. So you can't be transferred. So. Okay, next.
I do have a question on the tenancy or life tenancy. Can the life tenancy holder do any improvement to the house, or do they have to pay all the expenses on maintenance?
A life tenancy is is defined in terms of the instrument or agreement that allows and gives rise to that life tenancy. So the responsibilities and ownership and liabilities are all contained in the life tenant agreement. So you have to look towards that agreement that allows that life tenancy to have that life tenancy as to what the responsibilities are. So it's not an answer exactly, because you have to look at the instrument that gives rights to that power to find that out. So it all varies. It varies on how you.
I have one other question. Okay, thank you, Ivan. I have one more question from Stephen. When you buy a property with a divorce in progress, I believe it's divorce in progress, what the buyer need to be careful?
Oh yes, well this is very. I've I don't know. I feel that particular question is really relevant. It's in this last year more than any other time. COVID has this way of exaggerating any kind of problems recently, and every so often, and quite more often in the last couple of months than any other time before, I'm dealing with the sale of a property that is subject to two parties that are breaking up. Now, one of the most important thing to think about is that litigations, CPLs that are registered that may pop up any minute, anytime. Any agreement that you may have may become a disagreement at any point, any time. And so that a contract of purchase and sales that were both parties of the buyer, I mean the seller mostly, they agree, they may change their mind. You as a listing realtor of parties that are about to separate or in the process of it, it's really, really important to have an agreement already in place between the spouses as to how they're going to deal with the home. One of the most important things is decision making and how to break through a decision making tie. How to the seller comes, the buyer comes back with another counter offer. The husband wants to sell, the wife doesn't want to sell. How do you resolve that? The thing you have to look out for is insist on some kind of clarity in terms of agreement and decision making. So insist upon that, because things may just go backfire really, really quickly. The thing about CPLs in relation to, or spouse protection acts on properties, which may pop up anytime, and selling a property, and even if you're a buyer, you got to look out for this, is that it's not always just a financial decision, and this is the key. It's an emotional thing. It's wrapped up in all kinds of other issues: child support, spousal support, division of property, fair division of properties, unequal division of properties. And it's not just a matter of, hey, each of you own half and split the half after the mortgage is paid off all the adjustments are done. Is that, hey, things come up, and hey, remember your mother-in-law lived in their house for 10 years and we didn't charge her money, and we need to compensate us for that, etc., etc., etc. Remember a sister and brother-in-law that borrowed money from such and such and so and so. It is vitally important to have an agreement. And I've done these agreements where it's just dealing with the property. The most important thing for me when I have the situations is to have clarity in terms of who is making decisions. For example, 6 months for one of the spouse to do everything they can to sell the property. That for that 6 months, that one spouse has full authority, similar to the foreclosure proceeding when somebody having conduct of sale. They decide the price, they decide the value, they decide the contractual terms, the subject removal terms that they accept or not accept. The buyer comes back with counter offer. And if the first spouse is not able to get a deal that makes completes, then 6 months is for the next spouse to take over and be in control. And that's the thing that I prefer, is rather than have both people come to mutual decision. It's great if they can, but you have to really be careful because disagreements can come up so often. And I've had deals that are tied up. We finished the sale. The monies are in my trust account for a year and a half because the parties cannot decide where the money goes and who has to pay what. So before you do anything, you have that kind of a sense, get, get an agreement. If you are a listing realtor and you have that kind of a situation, make sure you have an agreement in place between the buyer, between the sellers, I mean, as to who is going to give instructions, because otherwise you're going to have so many things that may come up directly conflicting with each other. Although I've had clients.
Okay.
Yeah.
Ivan,
Sorry, I can just go on and on there. Sorry
I
about that.
know you can just go on, and I love it, but unfortunately, time is
Yeah.
of the essence.
Yeah, no
This
worries.
is our
No worries.
last question,
Yeah.
and anybody else who has questions, they can always email you at ivan@itlawcorp.com. Is that okay?
Oh, yeah.
Okay, last question. Does the unregistered spouse or common law partner need to inform the mortgagee before inserting the protection lien?
Well, you know, the quick answer is no, because the person who's not registered on title is going to be registering it, is doing that in order to protect its interest in the property. The idea is that they have ownership interest. Now, normally, normally the lender would have been aware of that. Nowadays, all lenders require the borrower who is borrowing that who's married and the spouse is not entitled to have the spouse sign something called a postponement of claim or waiver form. This waives their rights in favor of the bank to the extent of whatever the bank wants afterwards, and then the spouse can have access to any equity in the home. So, and I've known that many practitioners out there don't require that to be done in front of a lawyer without a certificate of independent legal advice. That is highly risky. So if you acting for a buyer that you know that is married, who's going to be registered on title with the mortgage, and somehow the spouse does not get in to be signed, is not required to sign anything to give up the rights, there's a problem there. Lawyers, notaries who represent the lenders as well as the buyer has to protect the lender. In this situation, if that happens, there's a liability issue waiting for the bank to say, hey, wait a minute, why are you putting a lien on this property? You have agreed with respect to the bank that nothing can stop the bank from its enforcement. So there has to be something there. Okay, so no, notice doesn't need to be done. But prior to that point in time, normally there was some arrangements for the lender to have protected itself already. Okay.
Great. Thank you, Ivan, for
Yeah,
such
thank you.
informative presentation.
Yeah, thank you very much.
As always, members, please contact Ivan if you have any questions or any legal advice or any word that Ivan can help you out.